Hi everyone, welcome to Legal Talks by Desi Kanoon. I am Suyash and I am excited to have started this show. On today's show, we will discuss yet another latest judicial pronouncement by the Honorable Supreme Court of India, High Court of Judicature at Madras, represented by its Registrar General versus MC Subramaniam and others. In this case, a question relating to refund of court fees on account of settlement between the litigating parties came up before the court. Now, there are two important legal provisions that were discussed by the court in this case. The first is the Section 69A of the Tamil Nadu Court Fees and Suit Valuation Act 1955 and secondly, Section 89 of the Code of Civil Procedure 1908. What is Section 69A of the Tamil Nadu Court Fees Act? It talks about refund on settlement of disputes under Section 89 of the Code of Civil Procedure. It provides that where the court refers the parties to the suit in any of the modes of settlement of dispute referred to in Section 89 of the Code of Civil Procedure, the fee paid shall be refunded upon such reference. Such refund need not wait for settlement of the dispute. Thus, in cases where the court has referred the parties under Section 89 of CPC, the court fees can be refunded under Section 69A. Now, what is Section 89 of the Code of Civil Procedure 1908? It talks about settlement of disputes outside the court. According to Section 89, where it appears to the court there exists elements of a settlement which may be acceptable to the parties, the court shall formulate the terms of settlement and give them to the parties for their observations, and after receiving the observations of the parties, the court may reformulate the terms of a possible settlement and refer the same for arbitration or conciliation or judicial settlement or mediation. There are many modes that could be adopted by the court here. Thus, according to the court, Section 89 of CPC must be understood in the backdrop of the long-standing proliferation of litigation in the civil courts, which has placed undue burden on the judicial system, forcing speedy justice to become a casualty. Similar is the purport of Section 69A of the Tamil Nadu Court Fees Act. This provision also encourages settlements by providing refund of court fees. In order to further understand the controversy, the court took recourse to two important case laws that talked about various interpretative techniques. Firstly, the court discussed the case of Directorate of Enforcement versus Deepak Mahajan, 1994, 3 SCC 440. In this case, it was said by the court that though the function of the courts is only to expound the law and not to legislate, nonetheless, the legislature cannot be asked to sit to resolve the difficulties in the implementation of its intention and the spirit of the law. In such circumstances, it is the duty of the court to mold or creatively interpret the legislation by liberally interpreting the statute. The second important case cited by the court was Sailesh Dhairyavan versus Mohan Balkrishna Lalla, 2016, 3 SCC 619. In this case, it was observed by the court that though the literal rule of interpretation till some time ago was treated as the golden rule, it is now the doctrine of purposive interpretation which is predominant. Now, considering such views, in this case, the court opined that it may, in order to avoid any difficulty or injustice resulting from inadvertent ambiguity in the language of a statute, mold the interpretation of the same so as to achieve the true purpose of the enactment. This may include expanding the scope of the relevant provisions to cover situations which are not strictly encapsulated in the language used therein. Further, according to the court, such an interpretation denying the party that is taking the lead in settling a dispute amicably and expeditiously leads to an absurd and unjust outcome, and a literal or technical or strict interpretation in this background would only lead to injustice and render the purpose of the provisions nugatory. The court also cited judgments by various high courts that have also taken the view that the provisions relating to refund of court fees in various state legislations read with Section 89 of CPC encourages speedy resolution of disputes, and keeping in view the huge pendency of cases all around the country, there is a need to adopt purposive and progressive interpretation of such legal provisions. In order to further delve into this issue, the court observed that the refund of court fees on account of settlement, whether it is through any of the modes including understanding arrived at privately by the parties having a stamp of approval by the court, is a sort of incentive to the party who has approached the court to resolve the dispute amicably and obtain a full refund. The modes of settlement provided in Section 89 of CPC are not exhaustive, and such settlements can be done through myriad methods and would include the out-of-court settlements as well. The court also stated that court fees acts are taxing statutes that are to be construed strictly, and benefit of any ambiguity in any provision has to go in favor of the parties and not to the states. Provisions like Section 69A are like reward to the parties who wish to withdraw their litigations in favor of more conciliatory dispute settlement mechanisms, saving the time of the court. In such cases, though the registry or the state government loses one-time court fee in the short term, but they are saved the expense and opportunity cost of managing an endless cycle of litigation in the long term. Thus, the court concluded by holding that Section 89 of CPC and Section 69A of the Tamil Nadu Court Fees Act are to be interpreted liberally and constructed purposively, extending their mandate to all methods of out-of-court dispute settlement between parties that the court subsequently finds to have been legally arrived at. Thus, the respondent was held to be entitled for refund of court fee. The crux of the matter is that if parties wish to settle their disputes expeditiously and out of the court, then they are free to do so, and provisions in the Court Fees Act and Section 89 of CPC incentivize this approach of the parties, and any out-of-court settlement that saves time of the court can be given the benefit of refund of court fees. So what are my concluding remarks? I think that the interpretative exercise conducted by the Supreme Court is in line with the need of the hour, that is, speedy disposal and resolution of the disputes. The state and the courts end up expending more money on the litigations than the entire worth and value of those litigations. This is a common scene. Such situations must be avoided at all costs, as it is nothing but a wasteful expenditure. Encouraging parties to go for out-of-court settlement is a nice strategy, and incentivizing the same in the form of refund of court fee would go a long way in reducing the pendency of cases in the Indian courts. So I hope you enjoyed listening to this show. Please do not forget to like and subscribe us. Thank you very much for listening. See you next time. Till then, stay tuned.